Hi everyone, my name is Courtney Forehand. I'm the Training and Marketing Specialist for the Colorado Municipal League. We would like to thank you for attending today's webinar. This webinar is being recorded and will be posted to our website. For those of you who are not familiar with the webinar format, you should see a control panel on the top right of the screen. You have an orange arrow to the left of the panel, which will minimize the entire box. All participants will be muted for the webinar, but are encouraged to ask questions by typing them into the question box on the control panel. We will hold a Q&A near the end of the webinar, but please feel free to type the questions as you think of them throughout the presentation. CMCA is offering a ½ point of a credit towards the webinars, the CMC or MMC designation for member clerks who are attending. To obtain this credit, you will need to complete the assessment found on the CML website and submit it to cmcaclerks@gmail.com. Today, our presenter is Karen Goldman. Karen is the former Deputy City Clerk of Aurora and has been offering insight and guidance to clerks across Colorado for the past several years through the Municipal Clerk Advisor Program, sponsored by CMO, CIRSA, and CMCA. Karen is very active in our clerks listserv, and she is the primary author to the election book, recently mailed out to clerks in CML member municipalities. We're very grateful to have Karen here with us today, and at this time, I will turn things over to her.
Thank you, Courtney. Welcome, everybody. Nice to see all of you. Well, the countdown has begun. Election day for the statutory town elections is less than 1 month away, and I hope all of you are ready or getting ready to go. Little bit about what we're going to do today. Normally in these webinars, I cover 2 topics at a time. Today we only have 1 topic that I'm going to talk about, and that is canvassing the vote. And what that means is that we're going to have quite a bit of time toward the end of this hour to answer questions, to talk about things. I'm guessing that all of you have heard about the coronavirus, and it's probably heavy on your mind relative to the election, and so we can talk about that as well. And what I want to do is to encourage you to ask questions not only about the topic today, but any other thing that you may want to know prior to your election. And also please be aware that I'm still available for answering questions out on the listserv. So with that, we will begin. So after the polls have closed, now remember, in a polling place election, anybody standing in line at 7 o'clock should be allowed to vote. And in a mail ballot election, please remember that only ballots received in your office by 7 o'clock on the night of the election can be counted. Postmarks do not count in the election. So what you're going to do is, once the election has closed, everybody has voted, you have all the ballots in, now your election judges are going to really go to work. They're going to tally the votes, and they're going to indicate the votes for all candidates and ballot items on a tally sheet. Now we're going to talk about 4 different forms that your election judges will be dealing with between the close of polls and the day of the canvass. And the first one is the tally sheet. And so the tally sheet includes the following information: the number of ballots from the ballot box. And the number of ballots should be equal to, or it could be less than, the number of ballots that were issued. And in a polling place election, obviously, when somebody comes to vote, they're given a ballot. The ballot has a ballot number. That ballot number is written in the poll book. Then their name is written in. The tally sheet will also include the votes for each candidate and ballot item, and then there'll be a place for the judge's initials. I did get a question as to how the items should be tallied, and the question was, do you go and you tally each individual thing on your ballot separately, or do you do it all at once? In other words, do you first tally the votes for the candidates, and then once that's done, do you go back and then do it for ballot items? And obviously, well, it's obvious to me at least, the answer is no. You don't want to be going back through your ballots any more times than you need to. So I would suggest that everything on the ballot be tallied at the same time. So once you have completed the tally, you make a copy of the tally sheet, you put it with the ballots back in a ballot box, and they seal it and you initial the seal. Any ballots that cannot be counted, and those would be ballots where you can't determine what the vote is, or there are undervotes. An undervote is where nothing is voted on, or overvotes where more than the required number of votes are obtained. Those should also be set aside. Now, if you have multiple items on your ballot and there are some undervotes and some overvotes, or some of the votes cannot be determined as to what they are, you don't put aside the entire ballot, because where there aren't those things, the vote is valid, and so those need to be counted. So then when this is all done, the judges create what's called a judge's certificate, and this is done in words. And I've given you the citation in statute where the language is to be, where you can find the language. Now, I have to tell you that I do not know why this is required. All I know is that it is required. You know, the election law, I've been doing this for a very long time, and some election law does predate me. So I really don't know in every situation why something was done the way it was done. But as long as it's in law, that's what we have to follow. Okay. Then we have a third form. So we've had the tally sheet, we've had the judge's certificate, and then there is a third form which contains the following information. Some of it is duplicative of what we have before. It's the number of ballots delivered to voters. That's either the number that's been mailed out in a mail ballot election or the number of ballots given to people who walked into the polls and votes. Then it's the number of ballots that have been voted, and that would either be the number of ballots returned in a mail ballot election or the number of ballots that were deposited in the ballot box. Now, I've seen in a polling place election where people get confused or they mark their ballot incorrectly and they're too embarrassed to ask for a replacement ballot, and they stick the ballot in their coat pocket or they stick it in their purse and they just walk out, which means you're going to have your count is not going to match up. Same thing with mail ballots. Some people just don't return them. It doesn't matter if the number of ballots voted is fewer than the number of ballots sent out. What would be a problem is if the number of ballots you received back was greater than the number of ballots that were sent out or voted. You also would include the number of spoiled ballots. Now, in a polling place election, somebody makes the wrong mark in the booth and they want another one. That's called a spoil ballot. In a mail ballot election, somebody makes the wrong mark. They come in and they want another ballot. In mail ballot statute, it's called a replacement ballot. But in each case, it is a second ballot that a voter will vote. And then the number of ballots not delivered to voters. And that would be in a polling place election, the number of ballots you have remaining from the total that you have printed that didn't go out. And in a polling place, in a mail ballot election, it would be the ones that came back as undeliverable. So those are the ballots that's what that means when it says not delivered to voters. So then there is a fourth and a final form, and it's called the abstract of votes. And this basically is the unofficial vote total. So it doesn't include any of the other information. It basically just indicates what was on the ballot. So it's the name of the offices, the name of the candidates for that office, and the number of votes that each person got in the election. It will list the ballot titles, and it says, the statute says ballot titles and submission clause. Well, what the submission clause is, it's basically the ballot title, which is written in the form of shall the blah, 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 yes or no. That's what you put in. That's what the ballot title and submission clause is. And then there will be a yes column and there will be a no column. And that's the number of votes counted for or against each measure. And then this is the one that you post in a conspicuous place on the outside of your polling location. It could be the door to your town hall. It could be if you've got one of these kind of stands in front of your building where you post notices. Wherever you post your notices, that's where it stays. Now, one of the things I want you to remember is that on election night, the votes that have been received are unofficial. And although they might be the same votes, that the same number as you determine following the canvass and therefore become official, they are still unofficial. And depending on circumstance, those votes could change. Okay, so let's talk about the canvass, what it is and what it isn't. Canvass by definition, I went to the dictionary and here's what it says: to examine carefully, to scrutinize, or to make a thorough examination. What it doesn't say is a canvass is to do again what the judges have done. So the purpose of the canvass is basically to review the election results, to look at what the judges did, and to verify those results. The canvass is not a recount. Even though a recount might be required following the conduction of a canvass, it is not a recount. So the canvass by law is conducted by the clerk and the mayor. However, if you don't have a mayor for whatever reason, or the mayor was on the ballot for election, then you don't use the mayor. And when you think about it, it makes sense. So if you can't use the mayor, here's who you do use: your municipal judge, or if you have an election commission, you can use a member of your election commission, or a person who's qualified to be an election judge but did not serve as one. So remember, in order to be an election judge, one merely has to be 18 years of age and registered to vote anywhere in the state of Colorado. And obviously, the reason that you don't want to use somebody who was the election judge is you don't want that person to be passing on the work that he or she already did, which is another reason why I always suggest that the DEO oversee the election and not get into the weeds of actually doing anything as a part of the election. And again, I've given you the citation as to where you can find the qualifications. All right. The canvass can be completed as early as election night, and depending upon certain circumstances. The canvass must be completed no later than 10 days after the day of the election. Just like when you are writing up your election calendar, election day is day 0, and the day before is day 1, 2 days before day 2, and so on and so forth. The same kind of thing holds true when you're counting after the day of the election. Election day is day 0. So the day following the election is day 1, and you count up to 10 days, and that becomes the last date for you to conduct the canvass. Here are the circumstances that would prevent you from conducting the canvass on election night or on the next day. The first has to do with the UACAVA covered voters. You'll remember that if you have UACAVA covered voters, these are people who are registered to vote in your community, but who are not in your community. They might be overseas when you think about the military, or they might be working in another state, or they might be working in another country. And remember, you send those ballots out to people 45 days before the day of the election. They also have 8 days following the election to return their ballots. If any of those ballots are returned up to 8 days after the election, then they are added to the unofficial count, and you can't do the canvass until you are assured that all of those ballots have come back. The other kind of circumstance that will prevent you from doing your canvass real soon after the election is if you're doing a mail ballot election, and in doing signature verification, it is clear that the signature on the back of the mail ballot return envelope does not match the signatures in the Secretary of State database, voter registration database, and you send out the letter asking people if they voted. And if you will recall, I sent out a copy of the letter, the form that must be returned, and a log to everybody on the listserv. So you should have gotten that earlier this week. If you have to send that letter out, they have until the 8th day after the election in order to return the form to you. If they return the form to you and they say, yes, indeed, I voted in this election, and they include a copy of the ID, then those set aside ballots also need to be added to the unofficial count. And so the canvass can again not occur until you've determined that those ballots have come back. So for people who have, for clerks whose elections include both UOCAVA voters and are a mail ballot election, or include UOCAVA voters and are a polling place election, ideally your canvass will not take place until the 9th or the 10th day following the day of the election. Here's a suggestion for how you deal with ballots that you might be waiting upon to be returned. I always suggest that a certain number of ballots be held out on election day if you have either UOCAVA covered voters or signature discrepant letters to be returned, or both. It could be anywhere from, let's say, 5 to 10. Nobody needs to know how many ballots you're holding out. But let's say you have 3 UOCAVA voters you're waiting on, and 1 discrepant signature letter that you're waiting on. And I'm just making these numbers up for the purpose of this idea here. Let's say only 1 of the UOCAVA ballots comes back in, and you know who it belongs to, and nothing else comes back in. So you've added, so the vote is going to change by 1. You and your election judges are going to know who that person is. And essentially, although you're not going to say anything, the integrity of the election and that person's vote is compromised because you know. But if you take that 1 ballot and you add to the 10 or the 5 or whatever number that you've held out, and you put them all together, and you are changing the vote by 11, no one's going to know how those 11 people voted. So I always think it's a good idea to hold out a certain number of ballots, and the county clerks must think that's a good idea because this is where the idea came from. So that would be a suggestion that I have. So the second major bullet on this page says the election results are considered to be unofficial until after the canvass has been completed. And it is my suggestion that the candidates should not be sworn in until after the canvass has been completed. And I know sometimes your next meeting is the day or 2 days or the same week as the election. But if you're waiting on ballots, it's never a good idea to get these people sworn in, because it could change, and the person you sworn in might actually not be the person who got elected. I can tell you in a recent recall election, on election night, there were 2 recalls. One was determined to be sufficient, the other one wasn't. After the canvass, however, because we were waiting, held out some ballots and we were waiting to see what came in. After the canvass, that recall that wasn't sufficient actually was sufficient. So it's always a good idea to wait, and I know everybody's going to be anxious to get on the board and get going, but I don't think it's ever a good idea to swear anybody in until after the canvass has been completed. All right, moving along. Things to look for when you're conducting the canvass. This is for you and your mayor, or you and your election judge, or you and the member of your election commission. That the returns include all the information required by law, and that means all the forms you filled out, the judges filled out, include all the information required by law, even though substantial compliance is the standard. In other words, you don't want to leave out, certain votes or that kind of thing. If there are omissions or there are clerical mistakes, then those can be fixed at that time by the election judge. A clerical mistake would be a misspelling on the abstract of votes, for example. Omission would be the math didn't add up. Somebody miscalculated or forgot to add, a vote that was on a second tally sheet or something like that. What's very interesting are the next two bullets, and that these are the actions that take place only after the canvass is completed. I know there were some very close races in the last November election, and based on the vote on election night, I heard from some clerks who were, this is my word, they were a little panicked about the possibility of having to do a recount. But and ultimately some of them wound up not having to do a recount because they were still waiting for other votes to come in. So I would say kind of hold your panic until after the canvass. But at the time of the canvass, when the votes become official, that's when you deal with a situation where there are tie votes. And at that time, the votes can be broken by lot when there's an equal number. And lot, breaking it by lot could be the same procedure you use for putting names on the ballot by lot. It could be drawing straws, picking a number, putting names in, in a hat, whatever. But once you have your official vote and you realize there is a tie, then you will schedule a time for which the tie can be broken. And I strongly encourage you to make sure that you contact the people, if it's a tie in candidates, that you contact the people who are subject to the tie to let them know that they can be available. And quite honestly, I think they should be available when you break the tie. And remember, a tie does not necessarily mean a recount. Okay, a tie is a tie, equal number, and you've determined by the canvass that that is correct. The judges did the right thing. That's when you break the tie. And again, at the time the canvass is determined or done, at the time the canvass is done, then and only then do you determine whether a recount has to be performed, but not before. So you can kind of hold off your panic or your concern or that kind of thing until you do the canvass. All right, now, once the canvass has been completed, then you issue your certificate of election. And that comes from the abstract of votes, which is what you've used to identify whether everything is correct. And it pretty much is the names of candidates, the total votes cast for each candidate. You can put your absentee ballots in a separate column. The one thing I neglected to add to this is if you also have items on the ballot, then it's the votes in favor, the votes against. It basically is kind of a repetition of the abstract of votes, but it also includes the signature of the clerk and the person who assisted the clerk in the canvass. Again, the mayor or a member of the election commission or somebody who could have served as an election clerk but didn't actually serve as one in the election. And then you take that certificate of election and you file it in the clerk's office. You publish it in your newspaper of general circulation. If you don't have a newspaper of general circulation or you don't do your legal notices, then you post it the way you would normally post things. And then you file your certificate of election electronically with the Department of Local Affairs. It used to be that we filed with the Secretary of State's office, but we haven't filed with them for a couple of election cycles Now it's done through the Colorado Department of Local Affairs. And if you don't have a login from them, you contact them and they will issue you a login. And then the other thing, obviously, you want to do is you want to contact the municipal league and let them know what happened in your election. So Melissa will be very happy if you are active and you do that so that she doesn't have to contact you. Okay, so it's very interesting is that after the election has been canvassed and the vote is official, it is at this time that you determine who gets a full year term and who gets the shortened term if you have 4-year overlapping terms and one of the candidates was being chosen to fill a vacancy. You know, we've gone through this before in previous webinars, how you fill a vacancy, how you determine who has the 4-year and who has the 2nd year and that kind, or the shortened term. It's at the time the election is official, the canvass has been done, and that's what you do. So I have a couple of more things that I want to talk to you about. However, before I do, I think now is a good time to start answering some questions that we have received. And I don't know how many we've received, but I know we've received a couple. Any questions you have either about this topic or about anything else that you either are concerned about or wasn't sure about or whatever pertaining to your election. So Courtney will read the questions and hopefully I'll be able to answer them.
So our first question, our first question is from Veronica. She is wondering what the emergency absentee voter affidavit wording should be.
The emergency absentee voting, and I assume you're talking about a polling place election. I think it's just a form that I don't have the statute in front of me. So what I'm gonna say two things, and if somebody else knows something different than me, I want to hear from them. I believe that the emergency absentee ballot application form is pretty much the same as the regular absentee ballot application form. And if you're doing a mail ballot election, you probably wouldn't need an emergency absentee ballot application form because number one, they would have already received a mail ballot and the form doesn't go out until after the Friday. The emergency form isn't available till after the Friday before the election. It's usually for somebody in a polling place election who intended to come to the polls on election day and then determined that they didn't. In a regular absentee ballot application form, you don't have to list any reason for why you're requesting an absentee ballot. And I think statute is pretty clear that emergency absentee ballot application form for somebody who suddenly realizes they're not going to be available. So my guess is it's the same form and you can just write the word emergency across the top when they come in to fill it out.
Okay, our next question is from Heather. She's curious that if a tie happens, could the candidates ask for the recount?
Well, as I said, in a tie, well, okay, the answer is yes. If in a tie vote, a candidate wants to do a recount, they could ask for it. But it is my opinion that in a tie vote, it is a tie vote, and you break the tie the way the statute indicates it, which is to be done by lot. And when you look at the formula for determining a recount, the difference in the vote, remember the difference in the vote has to be 1/2 of 1% of the number of votes for the highest vote getter. The difference, and I keep saying the difference in the vote, in a tie vote, there is no difference. So while you don't have to do a mandatory recount in a tie, where there's a tie vote, candidates at their own expense can certainly ask for a recount.
Okay, and Jennifer asked a question kind of leading off of this. It's and you sort of touched on it, but just in case, what do you do if there is a tie and how is it broken?
Well, as I indicated earlier, if there is a tie, you would determine to break it by lot. Now, remember when people get on the ballot, their names are put on the ballot by lot. So there's a variety of ways you can do it. You can draw straws or toothpicks. You can put everybody's name in a hat and draw the names out. And that's and whoever's name gets drawn is the winner. You can have them pick a card. High card wins, low card wins. I mean, there's a number of ways you can do it. It should be done with them present, and it needs to be scheduled at a time after the canvass has been done.
Okay, so our next question is from Bernadette. She has two UOCAVA ballots that have gone out. Do I have to have all 4 of my election judges come back to count the 5 or 7 ballots? Or can it be 1 or 2 of the judges? It's a polling place election.
You need, well, I don't, just because I think you need a minimum of 3 judges. No matter, anytime you're dealing with counting of ballots, you need a minimum of 3 judges. So if you've got 4 judges, pick 3 and bring them back in and let them know that they'll need to come back in and do that. The other thing you can do is you could hire different judges, but it's got to be, I would strongly suggest it be a minimum of 3, because you're doing the exact same process with the UOCAVA voted ballots that you're doing with all the other ballots. So I don't see that there would be any difference.
Jenny is wondering what the recount threshold is.
Well, I'm not sure about the recall, what you mean by the threshold, but if you look at statute, so the way it works is you take the votes. You take 2 votes. You get the higher vote and the second highest vote. And it could be from the first person and the second person. It could be the second person and the third person. But you take a look at the votes and you figure out what the difference is. And if that difference is equal to or less than 0.5% of the number of votes the highest vote getter got, then you have a recount. So for example, the highest vote getter, and again, I'm not a math person, so help me out here. So the highest vote getter got 100 votes. No, let's say 1,000 votes. 1% of 1,000 votes is 10. I think that's right. 0.5% is 5. So if the difference between, and Courtney's checking here on her phone for math, am I right there? Okay, so 1% of 1,000 is 10, right?
Oh God.
Times 0.1, 1,000 times 0.1. Yeah. Okay, so 10, half of 10 is 5. So if the top vote getter got 1,000 votes and the second vote getter, the second person got 998 votes, that's within the threshold for a recount. But if the person got fewer than 995 votes, there would not be a recount. That's how it works. So you got to be able to do the math, hopefully better than I can.
So our next question is, can you review active voter and inactive voter again?
Sure. The determination of who is active and who is inactive is determined by the county clerk, and it's based upon whether or not they have voted in either the general election, which is November of even numbered years, or the coordinated elections, which are in odd numbered years in November. Persons who regularly vote in November are considered active. People who have not voted in November elections for, I think, a period of 2 consecutive elections. And here's what will happen. If somebody is sent a mail ballot in November by the county clerk and the ballot comes back as undeliverable because the person has moved, then eventually they're going to be taken off the voter registration rolls. But if somebody is sent a ballot in November and they just don't return a ballot, then what the county clerk does in order to maintain its roles is that they contact the person and they say, you didn't vote in the election. We just want to know that you still live here. And if they respond by returning a postcard, they're still considered active. But if they don't do it after a couple of elections, they're considered inactive. The reason for all of this is because mail ballots are only sent to active voters. And the reason for that is because it saves on return postage. And so when you get your voter registration list, if you're doing a mail ballot election, if you get your voter registration list, you want to make sure from the county that you ask them for your active registered voters. Inactive registered voters are still registered. They're still on the books. They don't automatically get a mail ballot. They would have to request one, but they're still eligible to vote, and they can come to your office and request a ballot, and or they can come to your polls because they're going to be in the registration list, and they can vote. Hopefully that explains it. If not, tell me what I didn't do correctly.
So the next question is from Heather, and she says she has 3 discrepant signatures, and the difference in those 3 won't make a difference of the outcome of the election. Do you still have to wait to say the results are official?
How do you know that? That's my question back to you. How do you know it's not going to make a difference in the outcome of the election because you haven't had the election yet? Tell me how you know that. Or are you, unless I misunderstood, what you're saying is that yeah. So I want to know how you know that it doesn't make a difference, or are you asking if it doesn't make a difference?
We'll come back to that one.
Yeah, so Heather, please.
Yes.
Okay. If it doesn't make a difference, yes, you still have to wait. It doesn't matter if it's going to make a difference or not. You still have to allow everybody who is eligible to vote on the election to have the opportunity to vote. So your canvass cannot be completed until after the 8th day after the election. And as I said earlier, the official results may not be any different from the unofficial results, but you can't assume that until you wait until that 8th day and you conduct the canvass.
Jenny has a follow-up to her inactive voters.
Mm-hmm.
She says basically the inactive voter can get a replacement ballot if they come in and request one. Would I, as DEO, just look them up on SOS voter database site to issue the ballot?
Whenever somebody comes into your office asking for a ballot that they've not received, you always would look them up to make sure they're registered. So yes.
Okay, and Maria's question is what would happen if a ballot issue would have a tie vote?
Then I think I think on an item, not a candidate, because the tie vote, if you look at statute, as I believe that the statute regarding tie votes only deals with candidates, but I believe that on an item where there's a tie vote, it fails. Because in order to pass, it has to have 1 vote more than yes vote than no votes, and you don't have the opportunity to determine, I'm going to use the term play God in this particular situation, but you don't have the ability to determine the voter's intent. In a tie vote, you're not voting yes and no, you're just voting for candidates. So if a tie vote is in the item, so if there's a tie vote on a ballot item, then consider that item to have failed.
Cynthia is wondering what you're supposed to do when you get a returned unvoted ballot and how do you process that?
You set it aside and you don't do anything with it. You still go through the signature verification process, but when you open it and you start to count it, there's nothing to count. So you just don't have any tally for that particular ballot.
So Danielle's question is next. It says, I am holding a polling place election. If a person is registered in my municipality, however, needs to change, I'm sorry, let me rephrase it. If a person is registered in my municipality, but they need to change their address, can they fill out a change of address form and vote? Or does the change of address need to be verified through the county clerk first?
So what you're saying is somebody comes in, fills out a signature card. The address on the signature card is different from the address in the voter registration database. If that's the case, what I would do is I would let them vote since it's clear they moved within the municipality. And they didn't come from the outside to the inside. And then I would let them know that in future elections, they're not going to get a mail ballot, and they probably wouldn't have in the presidential primary if that's the case, and have them vote. But I would allow them to vote.
Those are all our questions.
Okay, all right. If you think of any more questions, keep bringing them in, and I'll be able to answer it. But I wanted to go to my next slide here. And at the risk of sounding like your mom or shaking my fingers at you, I just want to kind of give you an idea of some of the issues that have come up again and again during this election. I get I answer lots of emails, I talk to lots of people, and oftentimes once I answer a question, I have no idea who sent me the question. So I'm not singling anybody out for any of these things. But let me just talk about a little bit. And then there's one on here that I want to add that I didn't put on here because it just thought about it the other day. Anyway, here we go. So the first thing that I think was a big issue was, how do you include or exclude signatures on nomination petitions? And I always say that what we want to do is we want to err on the side of the voter. I know in small towns, the likelihood of the clerks knowing everybody or most everybody is pretty great. But I also want to make sure that you don't use your personal knowledge to guide you, that you verify. We don't want to be rigid. We want to allow shortened names. We want to allow nicknames. We want to allow those kinds of things if we can identify that the person signing is the person, because people don't remember how they're registered and they go by, nicknames a lot of times. So in other words, Ed or Ted is good for Edward or Edwin. Jim is great for James. Bob is great for Robert. Mel is great for Melissa. Margie is great for Margaret. Peggy is great for Margaret. I mean, there's all kinds of things. So what we want to do is we don't want to be so strict that we disqualify people who otherwise could be qualified. Some of the bigger issues, though, around the signatures on petitions came not from the name itself, but from the address of people being listed, including those of people running for office. And this is where your attorney needs to get involved. In fact, I have to say that during this election cycle, I've suggested more than ever before that people talk to their attorneys, because all kinds of issues seems to have been coming up. Where people will be, have a couple properties and they'll list one address as their resident address, but that's not where they registered, and that kind of thing. In situations like this, because statute doesn't identify or really acknowledge part-time residency, this is something where you need to talk to your attorney, and every attorney might be a little different on how they handle it. The other thing I found was that people have election provisions in their codes that are at odds with state statute. And I understand how this happens, especially if you live in a community where you haven't had an election in a long time. Elections have been canceled. You're going by what was in the ordinance that was passed back in the 80s or the early 90s. You haven't kept up with election code. You're brand new, and this is your first election. I get this, but what's really, really important is knowing what the law says. I honestly don't know how anybody can run an election without ever having read the statutes. The election book, the Secretary of State information, the fabulous cooperation given, provided by your fellow clerks. All of that is great. It is no substitute for reading the code and knowing the code. And in a statutory town, state rules prevail, whether it has to do with the date for circulating your nomination petition or write-offs or write-ins or canceling or things like that. It's really important to stay up to date and stay linked. And the way you're going to do that is you're going to, be involved in the Clerks Association, join CMCA. We have a lot of great information. We provide a lot of trainings, those kinds of things. So I would strongly encourage you to pay attention to what's in your code. We had a lot of premature concerns about canceling the election. It had just appeared that, I would get emails 3 days after the nomination petitions came out asking me, how do I go about canceling the election? Nomination petitions hadn't even come in yet. So I would just say, one step at a time, if it turns out you are going to cancel the election, then we'll deal with it, but don't worry about it till you have to. The same thing goes with write-in candidates. People, the only way, if you don't have an ordinance that limits who can be a write-in candidate and when they have to file to be a write-in candidate, then even if you have the same number or fewer candidates than you have positions available, you can't cancel your election. So you want to make sure, that you do have such an ordinance. And you want to make sure that the ordinance and the deadlines and all that comport with state statute. A lot of issues around canceling the election when you have both full and shortened terms on the same ballot. By law, you determine, as was on this particular, the last slide here, that the overlapping terms and who gets to fill the vacancy with the shortened term, that's determined at the time of the canvass. So technically, legally, you cannot cancel the election when both full and shortened terms are on the same ballot. Now, I have said that from an operational perspective is that if you can get your attorney and all candidates to agree that you can do that by lot, and your attorney's okay with it, and he or she's going to defend you, then maybe you can go ahead and cancel the election. And on a related matter, there is the issue of the full term and the shortened term. I've talked to a lot of clerks, and I say, what's on the ballot? And they say, well, we have 2 4-year positions and 3 2-year positions. And I respond by saying, and that's because you filled the vacancy, and either you don't know, they don't know, or they think you can have both. And the answer is no, unless you're home rule and you do something different. You either have 4-year overlapping terms or you have 2-year terms where everybody runs every election. And if you have 4-year overlapping terms, but you have people who are running for 2 terms, it's because you filled vacancy and the records are not clear as to who does which brings me to the difference between the term of office and the person who's in the office. If you've got somebody who was filling a 2-year term and is running, if they get elected, they may get the 4-year term because it's determined by the number of votes. What I'm going to suggest, and I understand that people haven't kept good records over the years, and I'm just going to put out an offer to say, once the election is over, let's sit down. I'm happy to sit down with you either over the phone or via email or come on out and visit with you to talk about how you can get back on track to figure out, what the staggered term business is, because not everybody runs. And if you have 4-year overlapping terms, then you don't have 6 people up every 2 years at your election. And that goes to the next one. And then the last one, I said, is it's the unfamiliarity with the election code provisions and too much reliance on others. Clerks are fabulous. The reason I'm still hanging around all you guys is because you are so fabulous and you are so willing to help out. And I think it's very easy to ask people to give you something or tell you something rather than do the research yourself. I love it when some clerk comes to me and says, this is what I understand the statute to be, am I correct? Because what that tells me is that they've tried to figure it out. That to me is much preferable than saying, you know, tell me how this works. I know it's easy, and I know you all are so busy doing so many other things, but it's really important. The last thing I want to say, and I just want to check, did we get any other questions? We have 2 more questions. So let me just say this last thing is that be prepared. I am going to suggest that at the time you create your election calendar, which you do well in advance of everything starting up, you also make a list by going through the statutes of all the possible forms and manuals and training items and things that you are either going to need or think you may need, so that you're not scrambling at the very last minute for something. And I think that's especially important when it comes to the campaign finance forms. I know a lot of you who, have never had to deal with campaign finance before. And now all of a sudden in this election you are, and you're scrambling, what are the forms that I need? What, when are they filed? How do I get them, and that kind of thing. If you have all this stuff in advance, kind of like, dare I say, disinfectant wipes, but if you have everything in advance, then you'll have it if you need it, and if you don't need it, at least you're covered. I know most of you probably aren't going to remember this 2 years from now when you have your next regular election. I just think it's a good idea to go ahead and be prepared. So that's what I have to say about this. And we have a couple more questions.
Mm-hmm.
All right, Courtney.
So Heather is asking that if you have an internal employment records that are including someone's photo ID and the signature verification is up for debate, can you use those internal employment records?
I'm assuming the question is can you use that ID when the person sends in their form? And the answer is no. If I'm wrong about what you're asking, let me know. The person who returns the form and says, yes, I voted the ballot, is the one responsible for including the ID. Now, the ID may be the same that's in the included form, but they have to affirmatively send you a form along with that return document.
Okay. Jay is curious that in a home rule community, does the municipal code trump the statute?
The answer is yes. In a home rule municipality, because you are home rule, if you have any procedure, rule, ordinance, whatever, that is different from state statute, that is what you go by.
And April would like a reminder as to where to find the sign up for the signature verification database on the SOS.
Okay, I don't have it in front of me, but I'm going to go through this. If you go to the Secretary of State's website and you look under elections and voting, I think if you go to manage my registration, then there will be, go to the menu and there'll be a line for administrator login. At the bottom of that, it asks you for that. An easier way, a much easier way, is go back to the webinar information I did. And the question was, how long does these things stay on here?
She's just wondering where to find the signature verification database.
In the Secretary of State's website, and you have to apply for DEO access. And so here's what I'm saying, but my question is, how long do these past webinar information stay?
I apologize. Yeah, they can still find our last
Okay, and you should, if you go back to the PowerPoint slides which were sent to you on signature verification, and you go to toward the end of it, I have some screenshots that show you how to get to it. but it's through the DEO access from the Secretary of State's website under elections and voting.
So our last comment on here is from Randy. She's giving you a shout out for the excellent information. But that seems to be all the questions that we have left.
All right, and I have one more thing that I want to tell you about. The CDC has provided some information on making sure that your polling locations, etc., are safe for your April 7th election. The Municipal League has very kindly added a link to the CDC information. It talks about what to do at a polling place. It also talks about how to handle mail ballots. The CML has also sent this link out on the listserv, so you'll have it. So I would strongly encourage you to read the information here on the link. And I want to wish you all a happy election. Lots of luck. I know you're all going to do a great job. And between now and then, any other questions, I'll be seeing you. And thank you again.
All right. Well, thank you so much, Karen, for your presentation today. And thank you, everyone, all of our listeners, for attending. Once again, we will be putting this PowerPoint and the recording onto the training for our website by the end of this week. Thank you again, everyone, for joining us. This is the end of our webinar, so have a great afternoon.